I'm Robert Preston, and I'm Director of Living and Dying Well. When I was sitting exams at school, more years ago than I care to remember, I was always told, before you start to answer a question, make sure you really understand it. So just what is the central question when we talk about what's being called assisted dying? It's not whether it's compassionate or cruel, or whether it's moral or immoral. It's whether it should be licensed by law. To be precise, it's whether doctors should be licensed by law to supply lethal drugs to terminally ill patients who seem to them to meet certain conditions. Now, to answer that question, we need to know what the law says, why it says it, and how it's applied. So in the next 10 minutes, I'm going to examine the existing law and consider what changing it to allow assisted dying would actually mean. I'm going to use some slides to illustrate what I have to say. So can we now start with the first slide? Let's start with what the law says. The law we're talking about is the Suicide Act of 1961. Under Section 2 of the Act, it's a criminal offence to encourage or assist another person to commit suicide. Anyone found guilty of doing that could be sent to prison for up to 14 years. Now, that might look like quite a draconian penalty, but you have to remember that that's a maximum sentence, and that a court isn't actually obliged to impose a prison sentence at all. And even more important, you need to look at what else Section 2 says. Section 2 also states that, and I quote, "no proceedings shall be instituted for an offence under this section, except by or with the consent of the Director of Public Prosecutions." In other words, if you've assisted another person's suicide, the Director of Public Prosecutions, the DPP, has to consider whether it's in the public interest that you should be prosecuted. Now, what does this mean? Let me explain. In deciding whether or not to prosecute someone, it's not just a matter of deciding whether the law has been broken. That's part of it, of course. If there's been no breach of the law, there can't be a prosecution. But if there has been a breach of the law, it's also necessary to look at the circumstances in which the law was broken. And that's particularly so when we're talking about complex and sensitive situations like this. The law recognizes that there's a fairly wide spectrum of criminality when it comes to assisting suicide. At one end of that spectrum, you may have a situation where someone has very reluctantly, after much soul searching and in response to persistent pleading, helped a loved one out of this world for wholly compassionate reasons. But at the other end, it could be a malicious or manipulative person who has pressured someone, perhaps an elderly relative, into taking their own life and has done that for personal gain or to be rid of a care burden. Now, deciding where on the spectrum any case lies depends on the evidence of what has actually happened. So the DPP has to assess the evidence from a police investigation and reach a decision. Now, there's nothing actually unusual about this. There's provision for prosecutorial discretion to be exercised for other criminal offences. Well then, if that's the law and that's how it's applied, the next question is, does it work? Now, my answer to that question is yes, it does. And I say that for three main reasons. First of all, the law provides a powerful deterrent against malicious activity. The penalties it holds in reserve are serious enough to make anyone minded to assist another person's suicide think very carefully indeed before proceeding. Now, one result of this is that instances of assisting suicide are very rare. On average, less than 20 cases a year throughout the whole of England and Wales cross the desk of the DPP. Now, by any standard, that's a very low level of law breaking. Of course, campaigners for assisted dying say the numbers are higher than this. They tell us that a few hundred terminally ill people commit suicide every year. But this misses the point. The law is concerned with assisting suicide, not with suicide itself. It's possible that some terminally ill people do commit suicide, but there's no evidence to suggest that any of these cases involved assistance, or indeed that the people concerned would have met the other conditions that the campaigners say should be part of an assisted dying law. And even if that were the case, legalizing assisted suicide for terminally ill people would simply result in much higher numbers of deaths. Take Oregon's law, for example, which the campaigners say is their model for what they want to see here. And look at the resulting death rates from it. If we had a law like Oregon's here, we'd be looking at between 3,500 and 4,000 assisted suicides annually. And Oregon's numbers of legalized assisted suicides are rising year by year. There was a 28% increase between 2019 and 2020. But the existing law doesn't just result in very small numbers of deaths. Thanks to the powerful deterrent that the existing law provides, the few cases that do occur are generally where there has been serious soul-searching and genuinely compassionate circumstances. Such cases don't call for prosecution, and they aren't prosecuted. Now, in a moment, we'll look at how all this would change under an assisted dying law. But before we do that, I want to touch on three important characteristics of the existing law. The first of these is that the law that we have now accurately reflects public attitudes to suicide. As a society, we rightly treat people who attempt to take their own lives with understanding and compassion. So suicide isn't a criminal offence. But we're also clear as a society that suicide isn't something to be encouraged or assisted. You can see this ethic at work in the suicide watches, where individuals are thought to be at risk of self-harm, and in the suicide prevention strategies that successive governments have supported. The existing law is completely in line with these attitudes. When the 1961 Act was going through Parliament, the responsible minister made clear that in decriminalising suicide itself, the government wished to give no encouragement whatever to suicide. The intention of Section 2 could not have been clearer. The second important characteristic of the existing law is that it applies equally to all of us, irrespective of our age, gender, race, and state of health. It doesn't say that we mustn't involve ourselves in bringing about most people's suicides, but we can do that for certain groups of people. It's quite clear that the protection of the law is there for all of us. And last but by no means least, the existing law rests on a rational and natural boundary. As Baroness Elizabeth Butler Sloss, a former president of the Family Division of the High Court, has written, laws are like nation states. They're more secure when their boundaries rest on natural frontiers. The law that we have rests on just such a natural frontier. It rests on the principle that we do not involve ourselves in bringing about other people's deaths. So let's now look at how all this would change if we were to go down the road of legalizing assistance with suicide for terminally ill people. Well, first of all, the social message changes. It's important to understand that laws are more than just regulatory instruments. They also send social messages. A law that says that terminally ill people can be given lethal drugs to end their lives sends the message, however unintended on the part of legislators, that if you're terminally ill, taking your own life is an appropriate course of action, at least something to be considered. Now, that message may not make much difference to strong-minded individuals who are accustomed to controlling their lives, and for whom the assisted dying proposals we see are largely designed. But most people who receive a terminal prognosis aren't like that. They're often victims of transient depression. They may be worried about the financial or care burden that their illness is imposing on those around them. People in this position can be susceptible to subtle changes in social messaging. The last thing they need is to find themselves in a position where society seems to be saying to them that perhaps they should take themselves off. Then there's the matter of the law's deterrent. Think about it. Under the law we have now, someone who, with malicious intent, pressures or assists another person into taking their own life has to reckon with a spotlight being shone on his or her actions and on any criminal behavior coming to light as a result. Under an assisted dying law, that deterrent would disappear. The only thing a malicious assister would have to fear is that the request for lethal drugs will be turned down. And that's not all. Think back to what Baroness Butler Sloss said about the existing law resting on a natural boundary. An assisted dying law replaces that rational and natural boundary that we don't involve ourselves in bringing about other people's deaths with an artificial and arbitrary one, that there are certain groups of people whose deaths we can bring about. There is in fact no rational basis for saying that we can assist the suicides of terminally ill people, but not the suicides of others. If, as we're told, compassion is the motive for assisted dying, where is the logic in supplying lethal drugs to people who are expected to die in the near future, but refusing them to others who may have years of chronic illness ahead of them? This is what's meant by the so-called slippery slope. Unlike the existing law, an assisted dying law rests on artificial and arbitrary boundaries, and as such it contains within itself the seeds of its own expansion. That's why wherever assisted dying laws in one form or another have been enacted, sooner or later they develop a dynamic of their own, and as their initial boundaries rest on no logical justification, they are easily overruled and extended. So what lessons can we draw from all this? I think the main one is that legalizing assisted suicide wouldn't just be a tweaking of the existing law, it would be making a major change to it. If Parliament were to go down that road, it would in effect be saying that there are certain groups of people whose lives we may deliberately end if they're requested and if they seem to meet certain conditions. Now, the campaigners will tell us that giving terminally ill people lethal drugs with which to end their lives isn't really assisting suicide, because the people concerned are dying anyway. Well, that's just playing with words. To say that is to make light of what's involved. The message it sends is that if you're terminally ill, we needn't go to the lengths we do with others to dissuade you from taking your own life. Suicide may sound like a harsh word, but it emphasizes the gravity of what's involved. In law, what's being called assisted dying is assisted suicide, and to attempt to reclassify it as something else is a dangerous misuse of language. Now, I don't doubt the sincerity of those who advocate a change in the law. The law doesn't meet everyone's wishes, but that's not what it's there for. And I can't help thinking that Lord Sumption, until recently a Justice of the Supreme Court, put his finger on it when he said in his 2019 Reith Lectures that the rule of law, and I quote, does not mean that every human problem and every moral dilemma calls for a legal solution. Thank you.